Hello, everyone. My name is Francesca Guerrero. I am a partner in Thompson Hine's International Trade Group. Welcome to today's discussion of the CHIPS Incentives Program. Launched by the U.S. Department of Commerce, it provides funding for projects involving the construction, expansion, or modernization of semiconductor materials and semiconductor manufacturing equipment facilities under the CHIPS Act of 2022. Before we begin, I'd like to address a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. The presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of the individual panel members and do not necessarily reflect the opinions of our clients, employers, affiliates, or Thompson Hine. The content should not be taken as legal advice, as the views expressed are for informational purposes only. If you have any questions during the webinar, please feel free to use the question box located in the control panel on the right side of your screen. There's a graphic here, and it will point you towards where you can drop down and enter a question. We highly encourage you to ask questions. We will answer as many of the questions as we can, both during the presentation and at the end of the webinar. And if we don't get to your questions, we'll follow up after the program by email or phone. In the handout panel, you can also download a copy of the PowerPoint slides as well as the bios of today's speakers. Today, I'm joined by my colleagues Chip Purcell, partner in charge of the firm's DC office and practice group leader of the government contracts group, and Kevin Oles, a senior managing associate in the construction practice. Again, thank you for your interest, and we'll get started. So, as we begin, I'll just note that a successful applicant under the CHIPS Incentives funding opportunity is going to be involved in a significant team effort. And so some of you on this webinar may know more about the Notice of Funding opportunity than we do. What we want to do today is focus on highlighting the legal considerations, some of which might be one line in the funding opportunity notice, and really raise those in your awareness. For those of us who are perhaps less aware of the CHIPS Act, just a brief overview. The necessity for the CHIPS Act was recognized by the US government when we had severe semiconductor shortages several years ago. The purpose of the CHIPS Act is to mitigate these shortages, to reinforce the semiconductor supply chain resilience, and to stabilize the availability of semiconductors through local production. So they're trying to onshore semiconductor production, grow semiconductor production, and safeguard national security via increased domestic sourcing. There are several different, we'll call them deployment pathways for the CHIPS Act funding. There's funding for commercial fabrication facilities, and that first opened earlier this year. There are research and development programs focused on semiconductor design, packaging, manufacturing. There are strategic initiatives by the Department of Defense to create microelectronics commons hubs, and 8 of those were announced, I think, earlier this fall or late this summer. There are Department of Commerce clusters that are intended to integrate suppliers across all the process levels. And there's the initiative that we're going to focus on today, which is the smaller scale initiative focusing on the supply chain, specifically semiconductor materials and semiconductor manufacturing equipment. This funding opportunity was announced in September 29th of this fall, and it's targeting projects with capital investment between 20 million and 300 million. That's overall capital investment. That doesn't mean the US government's going to give you $300 million. They are going to offer partial funding to incentivize this. The concept plan submission opens tomorrow, December 1st, and they're going to be accepting these initial applications until February 1st. There are a number of compliance requirements and regulatory requirements that are sort of noted in the application requirements, and some chunk of our presentation will focus on that. Briefly, and we do have a lot of ground to cover, so I'm going to move quickly, but if anyone has questions or wants to clarify anything, please type them in the box, and we'll try to answer them as we're moving if we can. But the types of qualifying facilities are, again, semiconductor materials and manufacturing equipment. So this is not the funding opportunity for fabrication of semiconductor chips. This is going to be things like polysilicon, photoresist, ancillaries, other chemicals and materials that are used in the production of semiconductors. It's going to be equipment, deposition equipment, etching equipment, measuring equipment. This is what the funding opportunity is for. And I'm just going to circle back. The funding opportunity, both the fabrication and now the smaller scale supply chain initiative, is focused on construction, expansion, and modernization of facilities. So you can construct a new facility, or perhaps more likely, you're enlarging an existing facility to increase production, or you're increasing the capacity of an existing facility, or you're adding a new production line to your facility, or upgrading a facility to produce more advanced items, or you're converting a facility that you used for one purpose to one that's going to fit a purpose highlighted by this funding opportunity. So if you're seeking funding under this opportunity, you're doing one of these things, and I'm going to back up, for this type of material. So I'm just going to pause there for a second. That was the brief overview of the funding opportunities purpose. And now we're going to kind of start getting into highlighting the expectations and requirements for an applicant. Some of these are actually in the CHIPS Act and not particularly highlighted in the CHIPS incentive notice of funding opportunity. Some of these are things that maybe were one sentence in the notice of funding opportunity, but as lawyers, we are familiar with them and we're like, oh, that's a lot of work. We need to highlight for you all that that's going to be a lot of work gathering that data. And so first we wanted to talk about national security concerns. So as I know many of you are aware, the CHIPS Act has restrictions on foreign influence in the projects. The goal is to encourage domestic production, to have secure supply chains that don't rely on foreign entities of concern or foreign countries of concern. So there are going to be various ways that the application process restricts who can qualify. And there's also going to be restrictions on what the people who qualify can do with the funding. And there's even going to be maybe some soft information that's gathered that might influence who's a successful applicant and who isn't. So there can be foreign ownership involved in the project, but you're going to have to identify anything that could result in the control of the project by a foreign entity or sharing of confidential information with a foreign entity. The funding is also not available to foreign entities of concern, and we'll talk about that in a little bit of detail. And if you're successful, you're going to have to enter into certain agreements that obligate you to report certain transactions like expansion overseas, technology agreements that I'll talk about, that would potentially violate funding restrictions. So the government can kind of keep track of what you're doing and see if they want to execute a clawback. We're going to talk about each of these. So what's a foreign entity? A foreign entity means a government of a foreign country. It means a company that's organized in a foreign country. It means a natural person who is not a permanent resident or citizen of the United States, or like a protected individual, like an asylee. It also means any person that is owned or controlled by a foreign government, or any person who is an agent, representative, or employee of a foreign government or a foreign country or political party. They have also provided guidance and issued regulations that further define foreign entity of concern. So regardless of what country we're talking about the foreign entity is from, if they're sanctioned or debarred or alleged by the Attorney General to be involved in certain criminal acts, then they're going to be considered a foreign entity of concern. There hasn't been too much focus in the press on that prong of foreign entity of concern, except by people who rightly wonder, how much due diligence do I need to do on my business partners? How will I find all of this information? And so that is a point to emphasize here. Most of y'all, as Kevin and Chip will talk about more, are working in teams, you're working in consortia, you're working on bigger projects. And so you need to be thinking about diligence on all of your partners in these projects to look for these and other issues. What's gotten more chatter in the press is the question of countries of concern, and specifically foreign entities of concern are going to include those that are owned or controlled by or subject to the jurisdiction of a country of concern. The countries of concern are linked to the defense industrial base procurement regulations. So it's like North Korea, China, Russia, and Iran. And which country is actually potentially interested in investing in semiconductor facilities? We're going to talk about China as, from a commercial point of view, the one that's most relevant. But these other countries are foreign countries of concern. So they've provided guidance, the government has provided guidance that if a company is more than 25% owned, indirectly or directly, by such foreign governments or foreign nationals or companies in such countries, it's going to be considered a foreign entity of concern. So a subsidiary of a company that's organized in China is going to be considered a foreign entity of concern under the CHIPS Act regulations. Also, a company that has 25% ownership. So that is a development of the regulations through this year. We also mentioned a couple of slides ago that there's going to be a lot of information that you have to provide in the funding application about your sort of foreign involvement, foreign influence. And what the funding application requires is that everyone submits Form SF-328. If you do any security clearance work, you're familiar with this form. If you don't, you're going to be surprised, which is why we're highlighting it, and we've taken snapshots for you, what it includes. So the SF-328 is going to include not only information about ownership, but also about companies that you own, or interests that you have in foreign entities. It's going to have questions about your officers and directors and senior management. It's going to have questions about people who can appoint those people. And then here, look at this last one. Does your organization have contracts, agreements, understandings, arrangements with a foreign person? So that is going to go to your contractual relationships. And Chip, I don't know if you want to weigh in on that one for a second, but the next set of questions is going to talk about indebtedness to foreign persons. It's going to talk about where your income comes from. And it's going to talk about sort of roles that you have or your management has in foreign person entities. So it's much more broad than just simply asking about your ownership. And Chip, if you want to highlight from the government contracts world a little bit more about how some of these can surprise people when they're filling out this form and doing a foci analysis, please chime in.
Sure. Well, I mean, for companies out there that are in the government contract space, but I think to Francesca's point, may have some level of foreign investment. We often see that companies that are looking to receive government funding or enter into the government marketplace and maybe doing work that gets into a classified space, this becomes an issue. And I think that one of the points to make here, to sort of go back to Francesca's main point, is just the length of time it takes to run down these issues and really understand factually who's involved at what level. So, to the extent that this is going to be an issue, I think that Francesca's discussion simply highlights that it takes a fair amount of time to collect this information and understand it.
Yeah. So this is one of those items that was like one sentence in the funding opportunity, and we wanted to pull out for you all so you realize how much time it might take. Another item that is essential to the CHIPS Act itself, I question how relevant it will be to this particular funding opportunity, but in the CHIPS Act, there's requirements for clawbacks if funds are misused in ways not intended by the Act. And essentially, the US government doesn't want to help fund a project in the US. That means now you've freed up money to expand your facility in a foreign country of concern. They don't want to be, sort of encouraging both. So they're going to require, and I'll get into the types of issues in a second, but they're going to require that if you are successful, you notify them on a forward-going basis of transactions that may be covered, even if an exception likely applies. And if you breach some of these requirements, there's going to be clawback of the federal funding that you receive. So to expand, one of them is this expansion clawback. So there's a 10-year restriction on the material expansion of semiconductor manufacturing capacity in a foreign country of concern. This is, this might be mostly relevant to companies that are actually fabricating semiconductors. So, they define it as wafer production, fabrication, bonding. If you all are processing chemicals and that's all your business does, then the definitions don't really seem to cover the expansion of processing chemicals in another country. However, if your company has multiple layers and levels, then you need to think about whether you're applying here for semiconductor materials funding, but in a foreign country of concern, you're actually doing some fabrication or packaging. There are exceptions to for certain like existing facilities that produce legacy semiconductors, meaning lower tech ones. But again, the government requires that you report to them even if you think it fits on this exception. The other main clawback is related to technology. So during the term of an award, and that's a little bit loose, right? Because we don't know what form the awards will take, and we'll talk about that. But successful applicants are going to be prohibited from engaging in joint research or technology licensing with a foreign entity of concern that's related to a technology or product that raises national security concerns. And there isn't a lot of meat to that yet. It doesn't apply to pre-existing joint research or technology licensing, but this is something to think about and honestly try and suss out a little bit in the application process. And Kevin will talk about how, this is a long-term, the application is a long-term process. You don't submit it and then sit back and wait to see, if you get your money. You're going to have many chances to engage with the US government during this process. Okay, and now I'm going to turn it over to Chip and Kevin to talk about some of the more economic security objectives of the CHIP Act and some of the regulatory compliance requirements for applicants.
Thanks, Francesca. So as Francesca said, we're going to go through a section that talks about elements that are called out on the funding notice that become components of an application. But we want to sort of highlight some of the legal issues that we see with these various components. And we suspect that you're all probably very familiar with these various components, but just want to provide a little bit of a legal perspective in terms of things to talk about. So the first one being supply chain resilience and risk management. Supply chain resilience obviously is one of the main objectives behind this whole investment program. In terms of the discussing an applicant's approach to supply chain resilience, the funding notice requires the applicant to talk about a plan to identify and mitigate supply chain security risks. And you see below the various kinds of risks that are identified: access, availability, confidentiality, integrity, lack of geographic diversification in the supply chain. So from a legal perspective, I mean, I think that encompasses a few things. I mean, one is sort of understanding laws that may come to bear in terms of identifying and managing these risks. Are there specific federal or state laws that are relevant to how you look at these risks, how you come up with a mitigation approach to each of them? And then contractually, and we'll get into some more of this too, what kind of agreements do you have throughout, within the organization, outside of the organization, to be able to take on the various mitigation approaches to managing the supply chain risks? In terms of thinking prospectively about how you're going to put together an application and then carry out an award, giving a lot of thought to sort of those two main components. Then going down the list, organizational approach to managing supply chain risks, resilience, and security. One thing, and Francesca, I think, hit upon this briefly, but if you wouldn't mind going back, Francesca, as an organization, you've developed some sort of overall approach in various levels of detail in terms of dealing with these supply chain risks. So how do you articulate that? How do you articulate it within your organization so that apart from what's put down on an application and may end up in an award, that everyone out throughout the organization understands what those mitigation approaches are going to be? And then outside the organization too, you have specific policies that are articulated to others who are going to be working on this project, so they understand what your approach is as well. And then last is ability to continue operating in the U.S. without access to non-U.S. facilities and personnel. I think with this one, certainly thinking about looking into agreements with suppliers, other resources domestically that would be able to help mitigate this particular risk. Having those in place as part of a project going in, so that if access to non-U.S. resources is cut off, you've got those internal domestic relationships already established. Again, going through some of these risks and what the legal considerations would be. So corporate approach to managing supply chain risk, and you can see their senior executive leaders' responsibility. So again, I think some of this touches upon articulating corporate policies, procedures, objectives that are understood within and outside of the organization. Two, I think some of this, if you are tasking particular organizational leaders to take on responsibilities, they understand what their scope of responsibility is through an employment agreement or other forms of codes of conduct. People understand what their responsibilities are when it comes to carrying out these objectives. Second is include information regarding the relationship with suppliers, such as long-term contracts. So again, it's contracts with suppliers called out as a sort of key element to approaching mitigation of supply chain risks. Do you have those already in place? Do you need to negotiate them as part of performance of an award? So, thinking about who those suppliers are and the key ones in particular, and how much time do you need to be able to put those agreements in place ahead of any sort of an award? Access to power, water, airstrips, material transportation channels. Again, that's understanding what the legal requirements may be to gain access to, an airstrip or a source of water supply. Are there regulations that you need to worry about with respect to some sort of governmental entity? And from an agreement standpoint, what sort of an agreement do you have to have in place with those parties, and how much time do you need to contemplate in terms of actually going through and executing on them? And then last, risk mitigation strategies to mitigate adversarial attempts to degrade, exploit, compromise the supply chain. So, do you have diversified suppliers? Can you use insurance for something like that? Do you have existing insurance policies that may help you address some of those risks? Obviously, contractually, contractual agreements are a risk mitigation tool there. Do you have quality processes in place with your suppliers that you can use and have visibility into any kind of attempts outside attempts to exploit, degrade the supply chain in a way that's going to be counter to the performance of a project. Next slide. So again, it's commercial strategy. The agency asks for the applicant to talk about their overall commercial strategy. Obviously, they're looking for the ability of the awardee or the recipient to have long-term commercial success. So do you have a plan to sustain the proposed facility without additional CHIPS incentives? Do you have access to capital? Do you have existing relationships with some sort of financial institution or some sort of potential investor? Those take time to develop and come with various sorts of obligations. Just contemplating what's entailed in establishing those relationships and actually formalizing them, so the access to capital could be there if needed. And then second, project specific customer end-on-end market demand, just thinking about, and the third too. So really, who are the potential customers here? Do you have existing commercial or customer agreements that are in place? Do you need to develop those as part of performance or prior to performance, to ensure that you've got long-term commercial success when you're performing this project? Next slide.
Yeah, and Kevin, as we move on, did you have anything you wanted to sort of share from experience with the fabrication funding opportunity, and sort of when the government tells us that they're looking for supply chain risk mitigation and commercial strategy, anything surprising or noteworthy from your perspective?
The point I would make is that the government would, or at least our experience with the CHIPS team, was that they asked detailed questions. They wanted very detailed answers. We had long narratives that we gave that CHIPS Act team in response to their questions. They were not interested in, brief blurbs of how something intended to be, but the plans that the organization, had that were, in flight or landing, not just, this is what we're going to do.
And Kevin, I'm going to spring this question on you in real time because I'm thinking about it now. Do you think that companies that are applying in this round, who are really looking to supply these fabrication companies, can utilize some of that work? Because, again, this is a consortium, this is a goal. Can they utilize some of that work about customer market demand, volume growth, customers that was already produced potentially by their fabrication customers?
It's a good question, and I certainly want to touch on it more later, but I think thinking about how these supply chain partners, how they build up towards that end fab input, because these are litho tools, these are, silicon, polysilicon. You have an end user that you're working towards, be it TSMC out in Arizona, one of the Intel fabs, or any of the other people who want to get into it. Micron is in New York. You have an idea of how your supply chain builds up. So you're going to have some idea, some concrete idea of how that's going to go. So it helps to have a consortium to help you, basically expand that thought process and how you're all going to work together to develop workforce and cooperate with each other and not steal resources.
Thanks, Kevin. I'm just kind of moving along.
Sure. So, and this is a slide that's sort of near and dear to my heart as a government contracts lawyer, because when the government's looking at making an award, whether through a contract, grant, or any other sort of agreement, they want to understand the applicant's technical ability or qualifications to perform a project. So that's not so much of a legal requirement as it is really sort of technical and past performance, I would say. So, drawing upon your experience and, articulating specifically how you'd perform the plan, I do think from a legal perspective, and that second bullet, construction plan, that encompasses a lot in terms of understanding wherever you're thinking about doing this project, the obligations that come with actually entering into some sort of construction project, and the permits and the licenses, other sorts of approvals that you may need, and those things obviously take time and they have a cost associated with them. But obviously understanding well in advance of any sort of application what those things would be. And the last bullet I'd hit on too, and this is becoming a growing, I mean, this has been an issue in federal government procurement, but in terms of government, allocation of government resources, is using it to support domestic industries, and particularly here, iron, steel, other construction materials. That, and particularly under the current administration, has become a growing area of focus, and I suspect will be. And I think that obviously has a cost associated with it too, if that's an area that's going to be an area of focus or concentration in a project, thinking about not only the sources of supply, but the associated cost that comes with it. Next slide, Francesca. Thanks. So obviously a big element of the CHIPS Act is workforce and community investment, and this notice of funding requires detailed discussion about the applicant's ability to address these various elements. So in terms of workforce commitments, from a legal perspective, again, with respect to training education programs and commitments from regional educational training entities, what does that look like in terms of formal agreements, or what level of commitment is required, over what term, and what does that entail? And thinking about, from an organizational perspective, but from a legal perspective too, the obligations that flow from making those sorts of commitments and how you're going to manage them overall as part of this, the project, the performance of this project. And going down to the second area, workforce strategy, looking at those, the one I would sort of hit upon is the last one, metrics and milestones. Not only how are you going to measure, workforce related performance using metrics or milestones? Is that something that's going to be included in any sort of resulting agreement? What are your compliance obligations that are going to come from that? Does the government have any sort of enforcement mechanism if you're not, meeting any particular, set milestone or metric? I mean, those are things to think about, ahead of performance. Next slide. So again, just looking at sort of the legal implications that flow from these requirements, in that first bullet, in terms of compliance with federal labor laws, Davis-Bacon Act being one of them. As I'm sure many of you know, there are a number of federal labor laws that come to bear when you're involved in construction. So having a good understanding of what those laws are, what they entail, the government's ability to, watch your performance. But from a cost perspective, if you're going to be paying people pursuant to these federal labor laws, what are those costs? And what do you need to be attuned to over the course of a project in terms of potential changes? And then community investment, again, all of this investment in terms of, and making relationships and commitments within the community, what is that going to look like in terms of forms of agreements, the commitments that come with them, costs invested on your part to support these various requirements, whether educational or climate related, childcare, affordable housing? What does that all mean? So again, from a legal perspective, these all carry specific elements and requirements, but thinking about that before performance and being able to articulate it as part of a proposal, we think is a sound approach. Francesca, I think you've got the next slide. I think you're on mute, Francesca.
Thanks. Yeah, we just wanted to quickly highlight some of the other compliance requirements mentioned in the application that might take more time than you realize. So you want to start working these in tandem with your more exciting business strategy plans. So environmental compliance, again, some of the permits and regulations that the project is going to have to be in compliance with need to be listed in the application. There's also significant information about how the design and construction methods are going to, increase resilience from weather and how you're going to track your climate goals. Cybersecurity, again, this might take more time than you anticipate if you have not already had to produce a voluminous information about your cybersecurity practices and how you comply with the NIST framework. So just be aware that you're going to have to provide detailed information there as well. And then for intellectual property, there's an expectation in the application. So you're going to want to make sure you write about this, that you have a strategy for protecting your IP from theft and improper use. So that means both like a cyber protection component and also a legal protection component, or, how healthy is your system for technology licensing and restrictions. There's also consideration given to applicants who are participating in some of these other R&D initiatives related to chips. So think about what that means and the requirements. And then just generally speaking, and this is a good segue to, I think, our next section on the agreements and drafting and negotiating them. But there's always special IP considerations around government funding. And Chip, could you talk about that a little bit?
Yes. So the general policy of the federal government is that when it funds the development of intellectual property, the recipient of the funding has the opportunity to take ownership in most circumstances of the resulting IP, and the government receives a license right. So to the extent the award of one of these agreements could result in the development of IP that as results from the funding that was received, there is the possibility for the recipient to exercise the right to take ownership in that IP. So, number one, understanding that. Number two, understanding that with that right to take ownership, the government has the opportunity to have a license right, and it's generally pretty broad, which means they can do just about anything with the resulting IP. But the other point to recognize is that, again, if you're bringing your own proprietary intellectual property to perform an agreement like this, it's always advisable to give the government a heads up that that's what you're planning to do, so they know that it exists and there's no confusion with respect to who owns what and when they owned it and who has rights in whatever that IP is. So, just be aware of those factors and keep them in the back of your mind to the extent IP is relevant here.
And this goes to sort of properly marking and identifying the IP that you are bringing to the project, right? Is there room, Chip, to negotiate around the scope of the license that the government gets?
There can be. I mean, it depends again upon the type of IP, and is it commercial? Is it something that's non-commercial? But I would say, as a general matter, yes, there's the opportunity to negotiate to a certain degree what the use rights would be.
Okay. So good. So now we'll segue into drafting and negotiating the agreements. And the notice of funding opportunity is not specific about the form of funding. So there's some flexibility there. And I think Chip's going to tell us a little bit about what these look like.
Yes. So the notice of funding opportunity calls out at least 3 various forms of agreements: cooperative agreements, grants, or other transactions. So I think the thing to just recognize here is these are different kinds of agreements. They some are more heavily regulatory based, some are not. Grants are governed by Part 2 or 200, pardon me, of 2 CFR. It's called the Uniform Guidance. So there's a whole host of regulations that govern how grants are performed, administered, the costs, how costs are treated, cooperative agreements, whereas grants, the government's more hands-off. Cooperative agreements, there's more in government involvement. So something to be aware of too. Other transactions, agreements tend to stay away from traditional procurement-based regulations. So I think, obviously we're looking prospectively and anticipating without a lot of specific guidance what these specific agreements may take, what in particular form or format. So I would say just be aware of the fact that there are different types of agreements the government can use, and they're going to involve varying degrees of, and we'll talk a little more about this, compliance, the terms and obligations that come with them, all of the elements that you're going to see in an agreement. Next slide. So as a general matter, with an award like this, there likely is going to be little room to negotiate, at least the standard terms and conditions that are going to be dictated by a particular form of agreement. There may be some room, but I think as a general matter, if they're form agreements the government is using as part of these awards, there's not going to be opportunity outside of what's set forth in the application in terms of the scope of the work that's been going to be done and all the elements we've been talking to. When it comes to the more standard terms and conditions associated with actually administering the agreement, those tend to be fairly uniform. So recognizing that. And the second bullet really highlights, I think, an important point, just again, looking prospectively in anticipation of award, is how are you going to comply with all these terms and conditions? And particularly for entities that may be new to receiving federal funding, compliance is a big part of the obligation that comes with performing one of these agreements. And it falls in these various areas that you see at the bottom of the page. So performance and financial monitoring and reporting. How do you track the costs that you're incurring, and to the extent you need to be reporting? And that may be to in compliance with federal labor laws, reporting on hours that may be worked or wages that are paid. What are your internal mechanisms to be able to do that? Record retention and access. Federal agreements generally require the recipient to maintain designated records for a certain period of time and grant a federal agency or some designated party the ability to come in and take a look at those records. How are you going to maintain them? Who's responsible for them? And making sure you know how long you need to maintain them. Audits. These federal agreements generally carry audit rights that allow the government entity to come in and take a look at not only the records, but the costs associated with performance of one of these agreements. So again, how do you maintain accurate records with respect to costs, allowing people to come in and take a look at them? Cost compliance. Particularly with grants, there are very specific rules when it comes to how costs are treated. Are they allowable based on the various types of costs? And then close out at the end of performance. What does that mean? What are your obligations in terms of winding down performance and making sure that everything associated with the agreement is taken care of? Next slide. And we're getting short on time, so I want to give Kevin more time to be able to talk. I think just a point here is that, anticipating an award with this federal funding, there are likely going to be subrecipients, contractors, vendors with whom you're going to be working. And as the prime recipient, just thinking about how are you going to be able to manage those relationships. And it really starts with negotiating an agreement that's appropriate for the party that you're going to be working with downstream, whether a subrecipient or a contractor or a vendor. So really starts with looking at the agreement that you've got. What are you required to flow down, not only in terms of the scope of the work that they're going to perform, but terms and conditions that they're required to comply with. And I'll just hit quickly upon that last slide, Francesca, and to hand it over to Kevin. Here, these are areas that are really are prime areas for the prime recipient to look at in terms of ensuring that their subrecipient is going to be able to comply. And part of that too is making sure you've got the ability to oversee their performance sufficiently so that you are assured that they are doing what they're supposed to be doing under an agreement. So Kevin, I'll hand it to you.
Well, thanks, Chip. I appreciate that. As Francesca noted, I am a construction attorney, so my knowledge of federal regulations, federal procurement requirements, and federal grants is significantly less than the other two people on this webinar. So I defer to them for all actual knowledge. We've run across some interesting lessons learned from prior funding rounds, and really want to make sure we pass on some of that learning to people as they're thinking about applying for this round. Francesca noted it earlier when she talked about this is a team effort, but there's a mantra behind this of it takes a village to apply for these CHIPS Act funding. There's a ton of streams of information that applicants are going to need to pull from. We've noted some of them, but you're going to have to, as Chip and Francesca pointed out, show how the project is going to cash flow, show how the applicant company cash flows, and show how the project will succeed with or without CHIPS funding. That's just financial. There's partnering with local government entities, state and local, because obviously you have to get that covered commitment, covered incentive first. But you also have to look at this project as something that's going to have long-term commitments to the workforce in the area, the area where you're going to site the project, and who those relationship partners are going to be for the long term. And when you take a step back and you look at this CHIPS funding, the CHIPS team appears to be looking for a project that is seated in the community, that has a stable supply chain, that's going to grow and develop the U.S. Semiconductor manufacturing industry, but also secure and spur growth in the high-tech industry in the space where it's seated. So I mentioned consortiums on this slide. I want to come back to them in a little bit, but that's another one to think about. One other is, as Chip and Francesca have pointed out, there's a lot of detail required for these, so there's a lot of organizational stress for this process. This is something that we found was a multi-month commitment to applying. In previous rounds, larger funding, so there's potentially a little bit more scrutiny, but it seems like the CHIPS team is dialed in, knows what they're looking for, and knows the questions they want to ask. So, some of these things, as Chip identified, dealing with IP considerations, IP concerns, if you haven't figured that out, in the next 2 months, you will have to figure that out, potentially transform your organization so that you can deal with this. Supply chain risk is another one that we found was a significant issue. Our clients know their supply chains. They know how to handle supply chains and supply chain issues. But if you're building a litho plant and you need specific air handlers for clean room manufacturing that have significant long lead times, it seems like the CHIPS team wants to know how you're going to deal with potential delays to that supply chain, how you're going to bring your plant expansion, modernization, or new plant online in the face of those potential supply chain risks. So what the CHIPS team seems to ask for is they're not going to help you brainstorm in the next couple of months how your project's going to get off the ground with CHIPS funding, but really how it's going to land and be delivered to the market with a little bit of injection from CHIPS funding. So it's a fully formed project. It's not a brainstorming process. Could you go to the next slide, Francesca? Thank you. To put a frank plug in there, we found you need a sophisticated legal team. It's in-house counsel and its outside counsel are going to be required to really help bring this process home. I've talked about organizational change as required to comply with some of these processes. Chip mentioned all of the federal requirements that are required to meet in the event that you actually get one of these grants. And if you are not one of those companies that already is a federal contractor and has the process necessary to respond to federal contracting requirements, you have to, deploy your team to change your organization and really get into compliance now in the event that you're going to get that CHIPS funding in the future. There's an interesting one as well sitting out there about Buy American requirements. If you go through this notice of funding, there's no clear indication that like Buy American Act provisions apply. We haven't seen a grant yet that necessarily requires Buy American funding, but it may be an issue that you want to think about. How am I going to meet Buy American now? How would I meet Buy American if a grant actually requires there to be Buy American restrictions? Because moving from no Buy American compliance to 100% is not an easy lift overnight. So you're going to need internal counsel who knows how to respond to those issues, and outside counsel who helps you, audit your processes, figure out where change needs to occur. There's organizational discovery in that process. And I'll talk a little bit about that near the end when we talk about, how long this process took. I want to go to the next slide so we make sure we have time for questions.
Although I have to say, I love the term organizational discovery.
It was interesting to figure out that we had the client had certain process in place, but then others had to be modified to make sure they were ready for CHIPS funding, as we were asking the questions necessary to find out, how are we going to answer the financial process or the supply chain process. We found that there were really sort of three major teams that you're going to leverage during this process. And frankly, none of them were within the organization itself. Those three teams were site selection. They were the construction contracting group, and then your local economic development teams. So going through each of those, if you already have a site, if you're expanding a current one, you probably don't have to worry about site selection as much. But if you're creating a new facility, if you're building in a new location, these CHIPS Act supply chains, they run to the fabs. And so you're likely constrained by the location you want to be. There's as Chip and Francesca noted, there's government requirements as to water, power. You need to figure out, and you need help figuring out with the site selection team where you want to place that facility. And that is the first big hurdle to really get over. The second is the workforce development that Chip talked about. You need to be able to describe your workforce at the construction level when you're building the facility, and then at the execution level once your facility is up and running. And those workforce development for construction is not something that an applicant typically has, offhand. And so you need to be able to engage with your construction partner who knows local labor rates, who's going to recognize the difference between, non-union, union, and paying non-union Davis-Bacon wage requirements, because all of that goes into a funding question, but it's also a legal drafting question as well. How do you account for those different requirements? And then the last one, as I mentioned, was your economic development teams. And this is where I want to talk about consortia. The easy is there's a force multiplier out there in your economic development teams, your consortia. For instance, in Ohio, it's an easy grab. Jobs Ohio and the Ohio Grant Alliance this month opened up what they call the Silicon Heartland Supplier Consortium. And what it does is, obviously Intel is building a plant in Ohio for semiconductor fabs, but the consortium is collecting supply chain partners to work on supplying that fab, all in Ohio. There's consortia in New York. There's a broader Midwest consortium, and I'm sure if you look around, you'll find one in Arizona, New Mexico, probably near the Micron plant in New York as well. But what that does is your covered incentive from your state or local institution. The consortia enables you to tag on to an incentive package that covers the entire consortium. And they also are helping each other in working on that, the worker investment and community investment process. So you can partner up with somebody else. This is not something that an applicant has to, create all on their own and develop all on their own. You can figure out how to share workforce investment and community development as a whole team, and not as a lone individual out in the woods. So the Jobs Ohio team has a semiconductor team that knows what they're doing, and they're a massive partner in helping actually respond to these notice of funding opportunities. I think we're going to the next slide. I'm moving quickly so that we have time for any questions that show up as well. This is we've talked about a bunch of information here, but these are time-intensive applications. We had weekly meetings touching base on where various deliverables were, weekly meetings with suppliers and construction partners to get information out that we needed and get deliverables back. And then, we were all constantly talking across the organization to our tax team, to our legal team, to our financial team, to try to figure out, what else was needed, what else, do we need to go fact find. And then what we found was there were fire drills in, as I mentioned, organizational understanding, organizational fact finding. We realized that processes had to change. How do we change those processes? What is needed? And then the CHIPS Act team started asking questions once we submitted our application, and we had to respond to those. So it was a thing of, we needed to start the team early, start the application early, really plow through and make sure we knew where we were all along the process. But then we couldn't let the team go because we had to actually answer CHIPS team's questions and make sure that, we had a team that was able to go pull information in fire drills in response to the CHIPS team. So that's a lot of information, but that's what we learned in some prior funding rounds, and hopefully it helps applicants for this round as well.
Thank you. That was some very helpful insights. And I'd like to encourage people, if you have questions, to type it into the little chat box there. But one question I'll raise, Kevin, which I sort of mentioned before, for companies that are applying this round, especially companies who perhaps don't specialize specifically in semiconductor related materials or equipment. Can you tell us a little bit more about how they can leverage the work done in prior rounds and the work in these consortiums to make this achievable? If they're still trying to decide whether to really commit, like they've explored a project, they're trying to decide. Can you tell a little bit more about that?
A lot of the work that those first couple of funding rounds did was they set out a lot of the guideposts for what are going to be the community development and the workforce investment. I mean, you can go and find all sorts of information about the various investments that like Intel is doing in Ohio as part of its investment in the Ohio region and its workforce work there. And so the economic development groups, the consortium, they're building on that process. They're not starting things all by themselves. And so, an applicant who's looking at this round, I think they're looking at a more established ecosystem for that workforce investment. And it's an easier landing than what I think those large fab manufacturers were doing when they first submitted their funding, which was really trailblazing. There's a lot of figured out information. So reaching out to those economic development agencies that are driving these consortium, they know what the workforce development work is and the community involvement. They know who to talk to get those covered incentive grants from your local or state institution.
Okay. And do you think there's any a question about any likely common mistakes, critical failures, and this is an open question that people should really remember to keep front of mind.
I mean, I'd defer to Chip on common mistakes that he finds in federal contracting, because I think that's one of the big issues.
Well, I do think, just touching upon what we were talking about before, these are applications that are going to be reviewed by the department for an award. I think that the real mistake will come not so much in terms of the elements of the application, because I think, as Kevin talked about, there's going to be anticipated to be a lot of back and forth and questions asked. I think that the mistakes, if you will, are really post-award and sort of getting your hands around what is it going to mean to take on the obligations that come from an award, not only as the organization, but with all of the partners that you've got, whether alongside you or below you supporting performance. What does performance mean for all of those parties, and thinking about it from a process standpoint, from a contractual standpoint, from a compliance standpoint, and who's responsible for managing all of that. I think that's mistakes are made when there's not enough thought given to those elements.
Thanks. That's yes, the post-award compliance. So we are right at the top of the hour, and I will just, as a reminder, applications are going to be accepted starting tomorrow, December 1st, closing February 1st, 2024. This is the initial application. I hope you can reach out to us if you have questions, and also to our many partners in the economic development world, as Kevin mentioned. Also, a quick plug: if you're not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. Our trade practice also has a blog, thompsonhinesmarttrade.com, where we have put out bulletins about this material, this project, as well as other developments. So yes, thank you everyone for your interest in attending today's webinar. Enjoy the rest of your day. Stay well.